Legal positivism and legal interpretivism. A lot of isms going on here. What are these all about? Well, let's talk about it. To understand legal positivism, it's helpful to have an understanding of natural law theory. See my previous video on that. Natural law theory basically claims that law and morality are connected, and human morality ought to be derived or is derived from the universe. Maybe it's a universe that God created, maybe it's just a universe that's self-created, who knows? The idea is that the law must be grounded in something transcultural, transhistorical, it's universal. We can have universal human rights, we can have a universal idea of justice, all these different things, because there are either, we can look at it different ways spatially, there's either higher ideas or more foundational grounding ideas that human beings aren't just making up. It's not just something that we've come up with and it works for us, so let's just do that. No, there's something more foundational than that. But legal positivism challenges that in a number of ways, and it does so primarily on the belief in science, and a specific kind of science and a specific way of thinking about empiricism and human knowledge, which we'll get to in just a moment. But there are 5 basic things to keep in mind as we go. First, for legal positivists, laws are the commands of human beings. Humans come up with these things. They're the contemporary language for how your society works. And how that society works, well, that'll have its own language and its own laws. So laws maybe describe our values, but they're nothing beyond that. They're just what you and I create. They may have value because they're useful, or they may be terrible, but we really can't blame God for creating them, and we can't blame nature for creating them. Laws are simply the commands of human beings. Second, there is no necessary connection between law and morality. That's not to say that legal positivists just completely ignore the morality part. It's just that the law and morality are treated separately. This is huge. There's a very stark contrast now between legal positivism and natural law theory in terms of morality. Again, it's up to you what you think is more accurate or what you think is more appropriate, but how we create societies, depending on which theory we choose, the outcomes can be wildly different. Number 3. The study of the law, having a philosophy of law, having this conversation we're having right now, is worth doing. It's of value. It's of significant value, especially for the legal positivists, if we can do it under the matrix of a philosophical or a philosophy of science mindset, looking at the internal logic of the law. And just because societies are creating these laws and they are relative to each culture, that doesn't mean that they're not of merit to study and analyze and to think about. That's the temptation. When you think of natural law theory, law has credibility because it has a universal standing. And if you take that universal standing away, then the implication is, well, then why even think about the law if it's just a bunch of hodgepodge stuff that people pull together? Number 4, legal positivists argue that the legal system is basically closed. It's a self-contained system in which decisions are made, correct decisions are made, based on rules through logic, through the use of logic. We talked a little bit about reason and the role of reason for natural law theory, but here the primacy of logic and a very specific kind of logic dominates, and those correct decisions in legal practice are based on the manifestation of logic, not necessarily, or clearly not, of morality or the good or flourishing or human happiness, but of scientific or empirical logic. And number 5, following on the previous points, the moral arguments that we make about right and wrong, because they cannot be determined by science or a strict logic, that is, there's no particular proof per se that you could find in a laboratory, or no particular verification principle for a lot of the issues of morality, especially the transient or fluid dynamics of morality that require interpretation. Science has a very, very hard time with interpretation. Then these things, morality in particular, are not admissible in law in the typical way. Interesting. In other words, if it's not scientific, if we can't understand it as we would other scientific things, we're not really going to talk about it. This is a strong form of positivism that flows on logical and empirical positivism that happened in science more generally, in which the belief was if it can't be true by definition or shown to be true by observation, then it's meaningless. We'll get back to this. One of the distinctions we see in logical positivism is the distinction between what law is and what law ought to be. The ought to be, refers to sort of a moral thing. It ought to be good, it ought to be better. And the legal positivists shy away from that. The natural law theorists really are compelled towards that, but the positivists shy away from that and say, whoa, what is the law? What is the law in Ontario, Canada, where I am? And let's look at the logic of that law. And we're not going to worry about the morality part of it. I mean, that may come into play in the application of law, but that's not the conversation we're having. Logical, or legal positivism rather, changes the conversation, and it changes the focus, and it changes the concept of law fundamentally. For people who don't like the sort of metaphysic of natural law theory, the belief that there's sort of an ultimate foundation to the universe that we might not necessarily see, a foundation to morality that we might not necessarily understand scientifically, people who don't really feel comfortable with that will gravitate towards this theory that claims to be more scientific, more absolute, more logical. Is it in fact more absolute and more logical? Absolute's maybe the wrong word. Is it more scientific, and is it therefore more practical or attainable or realistic? Well, we'll see. It's up to you to decide, but there are some reasons to suspect that in fact it's not, and that it doesn't really describe how judges act in the courtroom, as an example, but we'll talk. So what is legal positivism? At heart, it's a theory about human knowledge. It's a belief that humans can only know certain things, and we can really only know, and this is epistemology, we can really only know or have knowledge that comes through our senses. The fancy word for this is empiricism, knowledge that comes through our senses. Now, it's not just my senses, it's a collective whole. Science, natural science specifically, is in the business of looking at the natural world and saying, what is there? What can we see? What can we measure? What can we feel? That's real. So the law, very similar to that, asks, what is real? It uses reason to try and explain things, but ultimately, the source of knowledge is the empirical world. Morality has a hard time fitting into that. Talking about the good, talking about human virtues, we can see some of these things in the real world, but they're clearly not as easily discussed as, say, a piece of bread with mold on it under the microscope, which you can see and you can have other people see and you can talk about its physical properties. So which is the law? Is the law really a physical thing, which obviously it's not, but is it a kind of thing that we can look at as we would science? Or is the law really a compendium of moral ideals and beliefs? The first of the big problems with legal positivism is that it assumes a scientific world without interpretation, or a legal world that doesn't need to really worry too much about interpretation. Interpretation is you and I bringing our worldviews, our messy, subjective worldviews to the table in any kind of conversation. The belief that we can see without interpretation, that we can see objectively, that we can see literally without any kind of bias or prejudice, that's at the heart of the scientific method. I did my PhD in the philosophy of science. I spent a lot of time thinking about the philosophy of science and how science works, its methods, its data, its predictions, its reliance on data, the building of models and theories that need to be tested. And in a way, science is a very, very simple thing. When it gets applied to the world, it can become incredibly complicated. But the basic scientific method, of which there are many, but the basic scientific method is meant to get you and I connected to the real world, to kind of get past all the human subjectivity and biases that frustrate seeing the world for what it is. So legal positivism relies on the belief that that's possible, and that we can see the law as a list of rules or dictates or truths that judges can look at and then apply to the real world, as if it was an objective thing. Is the law an objective thing? Or is it full of sometimes arbitrary, often biased, prejudiced, creative ideas of judges and what have you? Morality can still figure into the conversation with legal positivists, but it's a secondary conversation. They want to see the natural world, and they want to discuss law as if it's a naturalistic thing. Natural law theory, the word natural law, implies that they want to do the same thing too, but notice they're going kind of behind reality to a metaphysic about justice and fairness and equality that you can't see in a test tube, that you can't put under a microscope. So their version of naturalistic is a little bit different than this more scientific one. Now, again, keep in mind that this is a particular kind of thinking about science, one in which there is no interpretation. More modern forms of scientific investigation, certainly philosophy of science, they're far more open to this idea that probability plays a role, that human interpretation must play a role, and this hard objectivity is really kind of a very, very difficult thing to pin down. But still, the hard form of logical, or legal, I keep saying logical, of legal positivism doesn't want that unscientific metaphysic. They yearn for that objectivity that may never arrive, but that's what they want. Legal positivism is definitely more of a legal theory of law than it is about the application of law. The application of law is another conversation. With natural law theory, I find that the application of law and the theory of law are far more connected and intertwined. And that may be part of my own personal dislike for legal positivism, that it tries to divorce both theory and practice, that these two things are taken as exclusive or maybe even contradictory in a way, depending on who you're reading. So again, legal positivists see the creation of laws as a human creation. So the legal authority in any given society isn't God, isn't nature, it's the people. Law is a social construct. Law is a social construct, not God, not a nature construct, not karma. This shows us, or this brings attention to the very interesting connection of law and power. That is, those in power, governments, lobbyists, wealthy companies that can buy influence, they possess the power, therefore they make the laws. Think about that for a moment. This is a very helpful thing to begin to think about. Is that true, that the real source of laws isn't even culture at large? The real source of law are those who are in power. And that seems to be largely the case throughout human history. Those in power have bent the rule of law in their favor. But is that completely the case? I don't think so. I think a lot of the social justice issues, I think a lot of the gains in women's rights and minority rights, I think a lot of that has happened despite what a lot of people in power want, which is a good indication that maybe all of the power, all of the law isn't in the hands of the wealthy or the powerful. Legal positivists recognize that the law is a sovereign authority for life. The question becomes, is law nothing more than the expression of other people's power, of those in power? Is the law really nothing more than the loudest, most powerful voices of that culture? In large part, I think that's probably true. Is that entirely true? I hope not. I don't think so. But that seems to be where we're going. If we're not careful, if we don't pin law to morality, what are we pinning law to? In this case, the legal positivists aren't really pinning it to anything outside of itself. It's just the creation of a culture, and we can study it and examine the law as a science or in a scientific way, and we shouldn't be appealing to any metaphysic or morality outside of that. End of story. Okay, that's not the end of the story, but you get the idea. Drawing attention to this idea that the law is a command of the sovereign power, the people who have the most power, the government, and that this serves political interests is interesting, because in natural law theory, the idea is that it's supposed to be the other way around, that the law is meant to serve human interests, human flourishing, life, the good. So if this is what's happening, that in fact, and this doesn't bear on whether these two theories are true necessarily, it's just that this legal natural positivism or legal positivism is drawing attention to this idea that the law actually now serves the interests of the few and the powerful is problematic for a number of reasons. H.L.A. Hart argues that there's a minimum level of natural law that exists for all human beings. Kind of like with Hobbes, we were talking about with natural law theory. So Hart can still be a positivist of sorts, but instead of saying there's natural law that manifests as a human flourishing or higher morality. He's saying sort of a minimum. So he almost wants to share a little bit with natural law theory. He does a little bit. This idea that all humans share common natural needs and limitations, such as vulnerability. Yeah, we're all vulnerable. Equality, limited resources. These are okay. And limited strength of will. Now, again, with Hart, the purpose of law is not to make humans better or to create a better society, like it is with natural law theory. But he is borrowing some of it. There's sort of a minimum self-evident good that we could probably all agree to without too many problems, which means that the arbitrariness of law is being curtailed a little bit. That it's not, good laws aren't just at the whim of powerful governments that want to use it politically. Good laws will respond to these minimum things of vulnerability, equality, limited resources, and limited strength of will. If we stand back a bit and ask just generally, what is legal positivism? How does it approach the law? Well, it does so by basically saying that laws are languages of any given culture and how they operate. So we can look at these languages that have their own unique idiosyncratic vocabularies, they have their own grammar basically. Languages work differently depending on their culture. And we try to study those and understand those, and that's how justice gets done. Justice gets done through that language. No one language is necessarily better than the other language, but each language has its own internal coherency, it has its own internal logic, and we can just look at that and analyze it, again, scientifically, and that's what we're doing when we're doing philosophy of law or thinking about law. When judges are applying the law of their own culture, they're appealing to that language, its own idiosyncratic, unique, whatever kind of language themes they have. Maybe their themes are primarily economic, whereas another culture, their themes would be primarily religious. But they're appealing to those, and they're making rulings based on those specific languages. Again, we can't compare these two apples and oranges. They're just two different things. So that's law. So the two big criticisms people have of legal positivism is that A, like logical positivism and empiricism generally, as theories of knowledge, they haven't really borne the fruit people expected. They haven't given us the objective universe that we believed they could. They've been highly problematic, and I'll leave that up to you to look into. But two, that separation of morality from the law, for many people, just doesn't make any sense whatsoever. And that further, kind of a third problem, but leaning on that second one, is this arbitrariness issue. That's really unsatisfactory for a lot of people. If the law really is arbitrary, it loses its power, it loses its persuasive force, it loses its credibility. And if it's not moral, if there's no moral expectation there, what are we, robots? I mean, how does this, isn't the law supposed to reflect culture in a way that's more than just a series of logical dictates or puzzles or pieces to be diagnosed? It all just seems too clinical for a number of reasons. Well, along comes Ronald Myers Dworkin, and he argues for this thing, basically legal interpretivism. It's not a word he uses, I understand it, but it's a phrase or a title that people have given to him. His philosophy is a direct challenge to people like Hart and his positivism. And Dworkin wants to connect law and morality again. I mean, he argues that the separation of the two, as I kind of agree with, makes things arbitrary. Just seeing the law as it is, without this is how it ought to be, is far too limited. And Dworkin argues that this kind of distinction or this separation is simply impossible. That's not how society works. It's not how courtrooms work. It's not how judges think. While the laws operate in society in specific ways, what happens when there aren't laws for specific cases? What happens when the hard case comes up, the unique case comes up, and a judge has to rule on a specific situation where there are no precedents? There's nothing to come before to say, this is what you should do. He needs to think it through. In other words, the judge can't just apply the language of the culture, he has to reason to a conclusion. Well, Dworkin argues that this is a perfect example of the need for the judge to apply legal interpretivism. He needs to draw on his life experiences. He needs to draw on the language of culture, of course, the norms. But the moment he does any of these things, he's going beyond just the pure dictates of the law. So, how can we really have logical or legal positivism when we see judges acting outside of the technical law in the application of law? Surely that's law. Dworkin argues, or he envisions the law as a story, each judge adding to the story, modifying the story, each judge writing their own chapter, looking backwards, of course, to what's happened in history, but also towards the future. A lot of judges right now are having to deal with new technological issues and social media issues, things that the law always lags behind changes in the modern world, right? Things are always advancing quickly, and the law needs to adapt to that. That adaptation by itself is an indication that legal positivism is a little bit too narrow in its focus. Dworkin isn't satisfied with legal positivism. He doesn't see it as a particularly convincing way of thinking about lawmaking or law application in the real world. When judges need to make decisions on hard cases, they're invoking moral principles of justice and fairness and due process. And this starts to sound a lot more like natural law theory than it does a pure analysis of the logic or the application of logic in the context. And so Dworkin's just calling out this idea that what he sees in the courtroom doesn't mesh with a pure logical or legal positivist approach. Dworkin seems to accept that in fact laws come from people in power. Okay, so we're back to that earlier problem of people in power having all of the influence over the law. But the suggestion is, once these things came into law, because of people in power and governments, those laws, as they were applied, needed to be interpreted, and they needed to be changed. Laws get changed all the time, and they get changed to fit the values of society. So the moment a law comes down to us from a sovereign, a human being, that law then gets filtered, processed, rethought, and reapplied, with the argument that eventually it becomes more than just a dictate of those in power. It becomes a living reflection of that culture. We buy into the law not because it's just a dictate of those in power, but because it reflects our values as a society, hopefully our understanding of truth and justice. Is it still relatively limited to our culture and our version of interpretation? Of course. But at least now it's more nuanced, and we might even call it more social in that respect. This draws us back to the natural law problem of legitimate law. Can we still have a legal positivism? In this case of Dworkin, he would argue that we can, and the integrity of the law exists because of the social political world around it supporting it. Not necessarily because of a god or not because of nature, but it has legitimacy because we've bought into it. We've bought into the law because it speaks our language. Does that make it any less interpretive? Does that make it any less arbitrary? No, and he seems to be accepting that this is largely a matter of interpretation. That strict logical analysis that we find with the scientific approach just doesn't seem to work. Now, the natural law approach, that's going a bit too far too. So we have three theories now: natural law theory, legal positivism, and legal interpretivism. How we run our cultures based on one of these three, or a mix and match of these three, will have very different outcomes. With natural law theory, we're told that the law ought to reflect the deeper structure of life, morality, the universe, that it is something natural that drives us all towards happiness and flourishing, a better culture, the good life. Pretty lofty stuff. With legal positivism, we're told that it's a system of rules, a language, the law is, a language of individual cultures. It embodies how things are done, not necessarily how things ought to get done. So this is the way it is, not necessarily how it ought to be. It is divorced from morality, by and large, not necessarily completely, and something we might treat through scientific thinking or method or an apparatus. And it's based on a very specific view of human knowledge, that we really only have knowledge that comes through our senses. And then finally, we have this relatively new entry, legal interpretivism, that says, maybe we should find something in between, that maybe the natural law theory and legal positivism are two extremes, and we need to sort of rethink how the law actually works as something relative to the views of morality and convention and culture. So morality comes back in, and relative to how the culture interprets concepts of fairness and justice outside of just pure logic dictates inherent in the law. And we can think about that in terms of simply how judges actually do their job, what they need to do, especially in hard cases, to make the law apply. My own bias is towards natural law theory and a little bit of legal interpretivism. My background in academics is hermeneutics, which is the study of interpretation, so I find that fascinating. And I like the idea that morality has a bearing on how we act, but I don't personally like the idea of just kind of an arbitrary morality. I hope, and again, maybe I'm naive, but I hope there's more to that. So that brings me back to the natural law theory, universal human rights. I believe strongly in that kind of thing. But at the end of the day, I think there's something to be gained from all of these theories about the law. The problem is no one seems as yet to agree on just how we ought to approach the law. And so we as society keep struggling from legal reform to democratic election that causes new laws to overturn previous laws. The obvious example there are environmental laws from, say, the Obama administration now to the Trump administration, environmental laws just being overturned. So this conversation is something that may feel esoteric or impractical, but let me say that I think it's very practical and very important that we begin to sort through just what do we mean by law. If nothing else, maybe just to sort of steer the ship in one direction consistently towards environmental protection for a little while, rather than just having the arbitrariness of political decision determining the fate of our planet.